Hello everyone, welcome to week 2 of Arrest, Search, and Seizure. This short presentation will introduce you to the topic of Fourth Amendment seizures in relation to Oregon law. We will begin by discussing differing types of police-citizen encounters. The first category is voluntary encounters, also known as mere conversation. Secondly, stops, and third, arrests. Not every interaction with police is a seizure. Voluntary encounters are not Fourth Amendment seizures. Police are free to talk to an individual while at the same time the individual has a right to disregard the officer. The Supreme Court said it well in the Illinois versus Wardlow decision found in your textbook. The court said that when an officer without reasonable suspicion or probable cause approaches an individual, the individual has a right to ignore the police and go about their business. The distinction between mere conversation and seizure is not always clear. Although an officer may testify the encounter was voluntary, the judge is likely to instruct the officer that the type of encounter will be decided by the court after hearing witness testimony about what happened. In determining the type of encounter, the court may consider if there was a show of authority by police. Secondly, did the police intentionally and significantly interfere with the person's liberty or freedom of movement? Lastly, would a reasonable person believe their freedom of movement had been significantly restricted? Next, let's look at some Oregon laws that relate to person seizures. We begin by looking at the definition of offense found at Oregon Revised Statute 161.505. An offense is conduct for which a sentence to a term of imprisonment or a fine is provided by any law of this state. An offense is either a crime or a violation. The definition of a crime can be found at ORS 161.515. A crime is an offense for which a sentence of imprisonment is authorized. The definition of a violation can be found at ORS 153.008. A violation prescribes a fine only. The first category of seizures is stops. A stop is a brief detention of an individual to issue a citation or make further investigation into a criminal matter. In criminal investigations, a stop may occur when police do not have enough evidence to make an arrest but have sufficient evidence to detain an individual. ORS 131.615 requires reasonable suspicion of criminal conduct to stop a person. Mere suspicion is not enough to make a stop. Stops for violations are governed by ORS 153.039. An enforcement officer may stop and detain any person if the officer has reasonable grounds to believe the person has committed a violation. The Oregon legislature has taken a slightly different route for traffic offenses according to ORS 810.410. Just like everything else, traffic is both crimes and violations. Examples of traffic crimes include eluding police, drunk driving, reckless driving, and other things of that nature. Like any other crime, reasonable suspicion is needed to stop the individual. To stop for traffic violations, the offense must be committed in the officer's presence or when the officer has probable cause to believe an offense has occurred based on a description of the vehicle or other information received from a police officer who observed the traffic violation. Finally, arrests can only be made for crimes. ORS 133.005 defines arrest as placing a person under actual or constructive restraint or to take the person into custody for the purpose of charging that person with an offense.